order the meeting of the Davidson County Election Commission of May 10th, 2021. Thank you for being here. We do remain under the mask mandate of Metro government, so please abide by that. Let me take up the first item of business, and thank you all for being here. The first item of business is to consider the April 22nd, 2021 minutes of the Election Commission. So, commissioners, please take a look at those, and once you've had an opportunity to review them, please let the chair know whether there's any changes or whether you're ready to vote on them.
Make a motion to accept the minutes as of April 22nd.
Commissioners, is it ready for a vote? Okay. Is there a second?
Second.
We have a motion and a second. All in favor say aye. Aye. Any opposed? With no opposition, the motion carries unanimously. The next item on the agenda is retention of counsel. We've previously discussed this issue at some length, and I believe we've entered into at least the terms of an agreement, and I was given the charge to go to Professor Blumstein and the Bradley firm and to put those agreements in writing. Those have been circulated to the commission members. Are there any questions from the commission members?
Chairman Delanis, I understand there was an additional trigger point included in the Bradley retainer agreement. Would you mind explaining that for purposes of the public? Because I think Bradley was working really hard to give us a bit of a lesser rate considering the public nature of the representation.
Right. As I understand it, the Bradley firm has reduced their rates, and then at a certain point, if their fees get up to a certain dollar figure, there will be a further reduction in the rate. And that's been placed in their engagement letter, but also carried forward in a supplemental letter that will deal with any litigation that results.
I appreciate the Bradley firm doing that for the public and the public trust. Thank you.
Are there any questions? If everybody's had a chance to review those materials, I would request a motion to permit me to sign the three engagement documents, two by the Bradley firm and one by Professor Blumstein. I'd like the authority, if possible, to sign those on behalf of the commission.
Mr. Chairman, I'd like to make a motion that we accept the arrangements from the Bradley firm as well as from Dr. Blumstein.
Is there a second?
Second that motion.
All right, we have a motion and a second. All in favor say aye.
Aye.
Aye. Any opposition? The motion carries unanimously. The third item of business on the agenda is to consider the vote possibly to place the for good government referendum on the ballot. And I think I would just preface that with the statement that this commission is not deciding on the merits of that referendum. It's just deciding whether it goes on the ballot and whether it has met the legal requirements that we're at least allowed to consider before placing it on the ballot. And we've looked at this issue for at least a couple weeks now. And this is something that we requested Professor Blumstein and the Bradley firm to study for us, and they have given us a privileged, lengthy memo on the topic, and they've also given us a non-privileged, shorter memo that is suitable to be disclosed to the public. And Professor Blumstein is here ready to present his views on this. I would ask the commission's thoughts on whether they've had a chance to review it. Professor Blumstein is prepared to give us a brief discussion of it, or he's happy to just take questions if the commission doesn't feel it's necessary for him to make a presentation.
I think it's pretty well summarized in the executive summary, so unless someone else feels the need to have that done, I'm happy to just proceed to questions.
Okay. Where's?
He's back there.
Okay. Professor Blumstein, can you come to the podium, please? And Mr. McMullen, too. Thank you both. We appreciate your work on this. Yes. Yes, please. There's a little red button. It should be on the bottom right. And it should go, it's not red, but if you punch it, it will turn red. There you go.
All right, thank you. We have, do I need to keep this mask on? I guess I do under the
I'm
rule.
afraid you do.
Okay, that's fine. I'll do whatever is required. So I'm pleased to dispense with a presentation. I have a presentation, but as I said, I speak for a living, and I've done enough speaking, so I don't need to give a presentation. I think we have a privileged, lengthy 17-page memorandum and a 2-page executive summary. The executive summary makes the general points, and we're prepared to just move to questions or discussion or whatever. And let me just say very quickly, without going into this, the major points are, there are 3 points that I would just like to make, and then we can go on to the questions. And that is that the 2021 petitions are sufficiently different so that the decision facing the commission is different than it was in 2020. We think the commission can go ahead and make this decision, and we recommend that. And secondly, that the issues raised by Metro, which we don't address in the executive summary, we think are not properly before the commission, that they're addressed to a court, but that's the longer memo, the privilege memo, it addresses that, and it's a little, if there are questions about that, it's a little delicate about not losing our privilege, so we have to figure out if the commissioners want to ask questions about that lengthier memo and about the issues that would be presented in a court, then I think we need to give some thought about how we do that. And so I think those are targeted at the court. And then the memo itself addresses for the commission's information how we think a court would analyze this and why there's a significant difference in how the court would analyze the 2021 petitions as opposed to a 2020 petition. if there is litigation, which I think is possible, but not for sure.
Do the commissioners have questions? Commissioner Hertzfeld?
I do. I was wondering, Professor Blumstein, and thank you so much for the very lengthy and thorough opinion that we received from you and Mr. McMullen. I'm sure it took a lot of work, especially I note when it's 17 pages of single-spaced, very dense legal research, that takes an extraordinary effort, and you did it all in a very condensed amount of time. So I want to thank you for your very good work on that. I did have a question, though, and going through the memo, there were a couple things that perhaps I overlooked, and I was just wondering if you could help me with that. I know that in the legal opinion that was provided to us by Metro Legal before your retention, there was a significant point about there being a date and 2 dates that were on the various petitions that had been circulated, and I was wondering if you'd included that in your opinion and I just missed it.
No, we did not. We thought that issue had been, in a sense, resolved when the signatures were accepted, that ultimately that was deemed to be an acceptance of the petitions. We have in our work product, and Austin was responsible primarily for this, but we have in our work product an analysis of the date or dates issue. And I can kind of share that with you.
I'd appreciate that, thank you.
Is that the date or date issue is not controlling on the commission. The commission is subject to state law in when it sets the date. And the petitioners had sought June 14th, or in the alternative, a different date. But they had proposed a date, and then they said, based upon the requirements of the law, they would take the earlier date, but it turns out neither the earlier nor the later date is available, and ultimately it's the commission's decision as to set the date. And so that if you approve the memo for the ballot, the commission would have to set the date.
But you don't agree with Metro Legal's position that the fact that there were 2 dates on the petition as opposed to 1 makes it a defect in form for a requirement to be on the ballot?
No, we don't think so, and we think the issue is in a sense gone away because the June 14th date is passed. It's kind of immaterial at this point.
Okay, and then I just have one more question. Thank you for that. I think the other thing that I may have glanced over was the issue of the severability of the 6 proposed amendments within the petition. Did I miss that in the 17 pages of dense research? And it's quite possible that I did.
I'm sorry, I just acoustically didn't hear the
That's
question.
okay, I'll take off my mask if that makes it a little bit easier.
Thank you.
The severability issue, because there are 6 different amendments within the one petition, and I may have glossed over that in reading the 17 pages of very good research that you and Mr. McMullen did. Did I miss it, or is that not something
we
that
only
you all
had
addressed?
one reference to severability because our view is that all 6 are legitimate, should go on the ballot, so we didn't have to address the severability. The one exception to that, Commissioner, is the issue of when the reference date is, whether it would be 2021-22 fiscal year or 22-23 fiscal year. And we thought there, if the commission and the vote is yes, if the commission puts it on the ballot and the vote is yes, this is on the tax rate question, then there's a question of when it would go into effect. The petitioner wants it to go into effect for the 21-22 fiscal year, and for the reasons we've explained in the memo, we think that could be viable, but it depends very much on the timetable. And if they miss the timetable for 21-22, there's a severability provision in that, and I think it's clear under the law that it would then go into effect for 22-23, and the 21-22 fiscal year would be not implemented, if you will, but the 22-23.
Kind of supplemented in. I just had one more question then on that issue, if it's okay. On that issue of severability, looking at the petitions themselves, it looks to me like and I just want to know if you agree with this, that it's the first two items, the limited property tax rates and the recall elected officials, that have a specific reference to severability. But then the abolish lifetime benefits, preserve voters' charter amendments, protect publicly owned parks, greenways, and lands, and protect promises to protect promises to Nashville, do not have individual severability clauses. Could you figure out a reason for that, or how that impacts the petition as a whole?
Yeah, again, since we thought that they all passed muster, we don't think that the severability issue is one that really that the commission has to deal with. We think they're all valid. Without a severability provision, you go back to the normal severability rules, and it all goes upon intent. And so ultimately the question is whether, if something is found to be unenforceable or not doable, then you go back to your normal rules on severability. And I think that that's where that analysis would go. But I think that's not really something that the commission would have to deal with. That's something that it's a remedy question that a court would have to deal with.
So then I think hopefully it's my final question. Hopefully. Lawyers always say that, and it never is. But hopefully it's my final question. So based on that answer, I just want to make sure that I understand. So based on your answer, if the abolish lifetime or other benefits for elected officials provision, for example, if that were to be found to be unconstitutionally vague and not enforceable, that particular clause there does not have its own severability clause. So would it be your position that the entire petition should be thrown out at that point, or that some part survives?
We'd have to look at normal severability law, so I can give you an impression. But
sure.
Since we didn't think that was critical to the commission's decision, I'm not prepared to give a definitive answer. But I think,
sure, your impression would be fine.
But I think my impression would be that anything is easily severable, because the For Good Government group has put 6 very distinct, textually distinct items beforehand. And I really don't think a court is going to strike that down, but if it did, it's very easy to sever that one provision from the others, because they're very distinct. And under traditional severability doctrine, you try to do what you can to preserve what you can, as long as it's consistent with the overall structure of the proposals.
Okay, and I said it was going to be my last question, but see, I lied. And so based on that answer, I know
No, you didn't lie. You're just a lawyer.
I just am a lawyer. I had to keep going. That's right. And so based on that answer, I would take from it then that you would disagree with the chancellor's discussion and opinion on severability during the last litigation regarding a petition with 6 different clauses in one petition.
Well, the last one was just, I want to use a technical legal term, but I don't have one, so I'll just use a lay term. It was a mess. And I think that in the context of a mess, you have to figure out what to do, and you really don't know what to do. And so she had an analysis of that, but everything is situational. And so it's not a question of agreeing or disagreeing with her. She analyzed this in the context of a mess. I think this is not a mess. This is a different set of circumstances.
Great. Thank you so much.
Are there any other questions for Professor Blumstein? We have no questions. Is there a motion?
Yes, our recommendation is that the commission vote to put this on put all 6 of these amendments on the ballot.
Okay. Do we have a motion?
Motion.
A
To put it on the ballot?
Yes. Is that
Yeah, I'll make a motion to put it on the ballot.
all right? Do we have a second?
I'll second that.
All right. Any further discussion? All right. We have a motion and a second. All in favor say aye.
Aye.
Any opposition?
Nay.
No.
Okay, so we have a 3-2 vote, and Commissioners Evans and Davis and Delanis voting A, and Commissioners Hertzfeld and Starling voting nay. Thank you, Professor Blumstein.
And Mr. Chairman, just now that the commission has voted, there's some, the commission has to decide when to set the date.
Yes.
And it's within 75 to 90 days.
Correct.
And for the reasons I explained in the privilege memorandum, it's important for the petitioners to avoid the severability that Commissioner Hertzfeld and I talked about, that be sooner rather than later, so that it should be close to the 75 days. So I don't know if you're prepared to vote on that now, but I would discourage waiting the 90 days and encourage the 75 days, because some of the arguments that were raised in Chancellor Lai's opinion go to the question of when this is effective. And I think that the better rule, but I'm a belt and suspenders person, but the better rule would be that if the voters approve, and that's a big if, but if the voters approve, then it becomes effective at that time. If Metro is deemed to be a home rule city, then there's a 60-day wait period. And so I would prefer to avoid that issue by having the issue kind of disappear, so that the vote is within 60-day time period at that point. And then the first Monday in October becomes the pivotal date, and I think in order to be effective. And so I think that if you look at kind of a cautious approach, then the election should be in such time so that it can be finalized before the first Monday in October.
Mr. Roberts, have you thought about what dates would be appropriate, considering our past practices and the facilities we have at our disposal?
Yes, Mr. Chairman. We are looking right now that the earliest date that we would recommend would be the 27th of July. That would be a Tuesday. One of the reasons why we pick a Tuesday for the election, that's a traditional election date for Davidson County, but also our facility where we store all of our equipment to operate election day is currently being used as a vaccination site. If we choose to have it on a Thursday, our poll officials would then interrupt vaccination on Tuesday to pick up all of their equipment.
Yeah.
If we have it on a Tuesday, they would pick up their equipment on a Sunday when the vaccination site is closed.
Yeah, that suits me fine. The only thing, I don't know whether you need a vote on that, because that would be within the 60-day window, so that would be perfectly good for all the reasons. But, Mr. Chairman, I don't know whether you need a vote on that date or not, but if you do, then I would encourage the commission to go ahead and set the date as Mr. Roberts has just suggested.
The latest date would be August the 3rd, a Tuesday, which would be within the 90-day window, but would also protect the vaccination site by it falling on a Tuesday.
Yeah, but again, I'm trying to avoid conflict here, and I think the best way to avoid the conflict is not to raise the issue as to whether Metro is a home rule city or not, because there are different rules that apply. So I think the first, Mr. Roberts, was it the 27th, Tuesday the 27th of July?
Correct.
That would be a date I would be comfortable with and recommend that the commission go forward on that basis. And if you need a vote, but I think the commission should finalize this, because things have a way of just kind of dragging on.
Chairman Delanis?
Yes.
I actually,
Is there
I think,
discussion?
yeah, I actually
Sure.
think we've got that set for
We do?
item number 5.
Okay,
So
all right.
Perhaps we could hear
So
it
you
after
wanna
item
wait?
4.
Okay. if we
That'd be
can
great.
wait. All right. Professor Blumstein, that is on our radar for item number 5, and in deference to Commissioner Hertzfeld, we'll take it up not immediately, but soon.
Okay, fine. And I'm available if you need commentary on the Metro Charter Amendment, both
Yes.
Mr. McMullen and I have had a chance, but on a very truncated basis. But we
Right.
will be glad as the commission's legal counsel to weigh in on that as well.
Okay, all right. The next item relates to something that was certified to us on Friday, the 7th, by Metro Council, and I refer to it, at least in my thinking, as Resolution 837, and it's a proposed referendum that actually relates to the Good for Government referendum in some fashion. And we've got two people here that are prepared to speak on that. What I would suggest to the commission, but subject to the commission's wishes, is that we let Councilman Mendes speak to that, and also Councilman Glover, who's also was involved in this. They're both here. I suggest we give them 5 minutes, if that's acceptable.
Is that fine?
Okay, all right. Councilman Mendes, will you approach and tell us about Resolution 837, please?
Sure, thank you. So I'm Councilman Bob Mendes, one of the at-large council members. And first, thanks for your service to the commission. I know this is a volunteer gig. So the resolution got passed on April 20th in the Metro Council several weeks ago. And I've got two asks. One of them has to do with if you have any discretion to exercise, and you clearly have some when it comes to the date, to exercise it in favor of the direction of 40 elected members of the Metro Council, not in favor of Mr. Roberts. And secondly, I'm going to ask that you put the council referendum that was unanimous, passed 40-0 in the council, all 40 council members voting for it, the mayor voting for it, on the ballot also at the same time, if you decide to have an election on the Roberts referendum. Resolution RS 2021-837 offers voters a choice. Despite all the fancy legal talk, the referendum from Mr. Roberts is a dark money funded with barely enough signatures that's designed to hurt Metro. I'm going to go a little bit more. It's designed to hurt Metro. It will hurt Metro. If you have discretion, and you've got some, you should exercise it in favor of the voters that y'all represent, not in favor of Mr. Roberts and the dark money. The alternative approved by the council, all 40 council members, would provide an option to preserve the current charter provisions. Mr. Roberts, we know that he doesn't speak for the county, and nobody in this room should pretend that he speaks for the county. He's run for election, always loses, files lawsuits, always loses, ends up getting with ethics sanctions. You guys should not, in a vacuum, forget the fact that the man gets sanctioned regularly by the bar authorities when taking into consideration what to do. This aims for paralysis of the city. Among other things, if this thing gets on the ballot and passes, the budget that Mr. Roberts asked for Metro of $3.2 million may end up being doubled. Before the end of the year, there will be maybe a referendum on tax rate, a referendum about redeveloping the racetrack, a referendum to vote for a new mayor and vice mayor because they'll easily get recalled under the new recall provisions, and probably a quarter of the council will get recalled also. So you guys are going to get used to being in this room if it passes, and you're going to have a much bigger budget. Again, if you have discretion, nobody should act like this petition is driven by anything resembling a majority opinion of the voters in Davidson County. On the other hand, the council provision offers a choice of maintaining most of the current substance of the charter, and again, approved by all the council members, including our most conservative council members. if you have any lawful basis to set the date, whichever way you do it, Professor, with all due respect, talked about he was only here to tell you about what you should put on the ballot and not hear about the substance. And then he just gave you a substantive argument about how it helps Jim Roberts' petition to have the election in July instead of August. It's nonsense to do that, to make a decision on the election, to guess what's better for Mr. Roberts' petition and choose to do it in July. Again, setting aside all the fancy legal talk, what that means is he's making the argument to set up a situation where we would change the Metro budget 4 months into the fiscal year. That's ludicrous. The only things that would end up doing is cutting out the new school funding that the mayor proposed, or cutting out the new Southeast precinct where the mayor proposed hiring 40 police officers for that. That's all that'll happen if you bend over backwards to set it in July and leave the window open to change the fiscal year budget 44 months into the year. Again, please don't distill this down to just fancy legal arguments. If you have an opportunity to exercise discretion, 40 members of the Metro Council voted for this. The mayor signed it. And the purpose is to preserve the current charter provisions over Mr. Roberts' effort to try to take down the Metro government. So please, any discretion you got to exercise it in favor of the voters, not Mr. Roberts. And if you put it on the ballot and have an election, please put the council provision on the ballot at the same time. Thank you. I'm happy to take any questions.
Commissioners, do you have questions for Councilman Mendes? Yes.
Councilman Mendes, so the question you made a statement of, you said most of the substance of the charter. What substance is missing?
Excuse me?
Your statement was most of the substance of the charter was there, but my question to you is what substance is missing?
If I said it that way, I might have misspoke. The amendment that the council passed to put on the ballot would preserve the current provisions of the charter rather than the changes that Mr. Roberts' petition has.
So could you be more specific?
Sure. Mr. Roberts tries to make a referendum happen every time that the tax rate would be increased more than 3%. The charter amendment proposed by the council would blunt that, so you could only have a referendum if allowed by state law. If required by state law. That's one example. There's other places where Mr. Roberts' language creates a clear conflict between Section 3 and Article 18 of the Charter, where there just would be conflicting provisions if his language passed. And the council amendment is designed in that particular situation to tell people interpreting the charter to use Section 3, not Section 18, if there's a conflict. That's another place. There's other places where Mr. Roberts' language, just like last time, has undefined terms, like the term professional sports team is used. We don't know whether that's a roller derby team. We don't know if that's soccer. It's not defined. The council-driven amendment would provide a definition for professional sports team. There's I could go on.
Well, my question, the reason I'm asking, because I'm looking at one from your statement. Your statement implied when you said it that what you were proposing was missing elements. So that's why I asked the question originally. And then as I looked through, as referred to it as Resolution 837, I think that also would, from my reading this, and that's why I'm asking questions, so I have understanding, that some of this would fall in the same context of your actual statement, that it's missing substance. In regards, there's some substance missing as well. So I'm trying to get understandings for clarity.
I'm sorry, I didn't mean to suggest that the council amendment has any missing substance.
Well, that's how it came across. That's why I'm asking, because to make sure we have a total understanding.
The full understanding, sorry for not getting it right the first time. The full understanding is just like the one in the fall created a mess of the charter. This one, even if it goes on the ballot and passes, will create a mess of the charter. And the council's proposed amendment would fix the messes in favor of the current version of language in the charter.
I'll push pause on my question at the moment. Chairman?
Any other commissioners have questions at this point? Councilman Mendes, I have a few questions. You told us, and I think you're right about this, that this was passed through the City Council on April 20th. We did not receive it as a certified proposed amendment from Metro Council until Friday, the 7th of April, which was 17 days later. Do you know how that happened?
Yeah, I mean, I can find the email for you. That's just not true. The Metro clerk is responsible for sending it over to the Election Commission, and the Metro clerk sent it to Mr. Roberts the day after on the 21st or the 22nd.
No. It may have been emailed, but it wasn't certified by the clerk, so we could consider it until Friday, just a few days ago, because, you know, we were looking for it because we can't act on it until it's certified to us. So I don't think I'm wrong about that. But you don't, do you have, because it was certified to us on Friday. If it had already been certified to us before, there would be no reason to recertify it. But it was certified to us on Friday, and we accepted it, and we put it on the agenda as quickly as we could. So you don't have any explanation as to why the certification was received just a couple days ago?
My understanding is it was sent the day after we passed it.
Okay. How long did y'all work on this proposed amendment?
The first time it was on the council agenda was the first meeting in April, and then we deferred it for one meeting till April 20th to allow time for the charter revision commission. So that's not the council body, that's the body that created by the charter, the commission of people who are supposed to comment on the sanctity of the charter. They had a meeting between the April 6th and April 20, and unanimously voted in favor of having this move forward. And so we took it up again on April 20 and passed it 40-0.
Okay, but when did you start working on it? I know it first got introduced. It was filed with City Council on what date? Was that on the 6th?
It was filed. It was filed a few weeks before it would have been on an agenda for the first time.
Chairman, if I could help,
Sure.
It seems that the legislative history is the last page
Yeah.
of the item marked as number 4 in your packet.
Right.
There down at the bottom where it says history of legislative file.
So it was
if that's helpful.
filed on March 26th, I believe is what it shows on. But how long did you work on it before it was filed?
Well, I mean, I started working on it around about the time you are considering Mr. Roberts' last attempt at this, just the way I'm working on now, the next one that he's going to do after this.
I think he submitted his on the 25th. So, I mean, you didn't just work on it one day and then submit it the next day to Metro Council. I mean, would it be fair to say this was at least a month in the preparation to do something of this detail? I mean, it's got a lot of stuff in here for us to review.
I worked on the concepts on my own in advance, and I worked on it with council in the couple of days between when Mr. Roberts dropped off his petition signatures and when we filed it.
All right. And as the Metro Legal Department, did it have a hand in preparing this?
They had an opportunity to comment.
Okay. Have they issued any opinion letters concerning it?
If they had, they'd be privileged, but no, they haven't.
Okay. And then did you have assistance from the lawyer from City Council?
I mean, he reviewed it also.
Okay, all right. Let's see, and it's got, let's see, so it has a summary, and it has 8 sections. I believe that's right.
I don't have it in front of me. You say so.
Okay, but several sections, I think at least 8. Are they to be considered together? Are they one unit? They're not separate amendments, they're one proposed amendment.
The council resolution is drafted to be a single amendment.
Okay, all right. And then did Metro Legal prepare the summary?
My understanding, no, was the short answer to your question. My understanding is whatever the council puts for the summary, Metro Legal has the ability to change, fix, correct anything before it actually goes to the ballot. So this is, other than their opportunity to review while the legislation was pending, it does not represent their work.
Okay, so is the summary part of the amendment? In other words, are we being asked to put the summary on the ballot, or are we just being asked to put the 8 separate sections on the ballot?
As I'm sure you're aware, the charter requires there to be a summary, and
Right.
So the summary would go on the ballot.
Okay. Now, I thought state law requires Metro Legal, or the city attorney is a language that's used in the statute, to prepare the summary.
Every time this body has ever approved one of these, the council resolution has had language, and my understanding from council director John Cooper is that legal has the ability to change it if it goes actually on the ballot.
But at least you, as the proponent of this measure, it was your intent that the summary be part of the amendment.
We followed the same practice and procedure that this body has seen every council-driven resolution. And the proponents, the 40 members of the council and the mayor.
Okay. In looking at the amendment to Section 607, that's the property tax provision. As I understand it, what your proposed amendment does is basically it says that the good for government proposal will only be effective to the extent it's required by state law. Is that the intent?
I think that's generally correct, yeah.
All right. If it was already required by state law, there wouldn't be any need for the good government referendum, right?
There isn't a need for the good government referendum.
Right, but if state law already requires this, then you're basically, wouldn't it have been easier just to say, if you just voted for the good government provision, you're now voting against the good government provision? Because that's what this does, right? Doesn't it just take out of existence the good government provision on the property tax?
I mean, I think that's an overly simplistic approach, Mr. Delanis. What it does is it would give the citizens of Davidson County the opportunity to make the choice that going forward, the charter is intended to only have referendums about property tax to the extent required by state law.
But state law doesn't require any referendums, does it?
That's an excellent point. Why would we do it in Davidson County?
Well, because I don't want to debate you, but it's in our but it's in our charter to do that. But it doesn't require referendums anytime in any county, in any city. It doesn't require a referendum.
I mean, with all respect, you seem to kind of want to debate it.
Okay. let me ask you about Section 1. And I'm paraphrasing, but Section 1 basically says that the authority of the city council and the mayor to pass ordinances and to legislate will supersede everything in Charter Section 18.
I'm sorry, I don't mean to interrupt. Could you tell me where you are, Chairman Blanes? I'm just trying to follow along.
It's the amendment that, let's see, the very first
For Section
amendment.
3
Says Section, let's see, yes, Section 305.
of Article
Section
3?
305.
Right there at the bottom of
Yeah,
page?
yeah.
Okay, got it. I got it. I apologize for interrupting.
Yeah, that's fine. No, absolutely. I'm happy to clarify. It says, in the event of conflict between this section and any provision of Article 18, except Section 1802 of Article 18, this section shall prevail. And if I think I'm reading this right, basically, this section 305, is what gives the Metro Council the authority to legislate, to pass ordinances.
I believe that's true.
Okay, so that section and Metro City Council's authority to pass ordinances is, by your proposal, it prevails over anything in Section 18 of the Charter.
Except for 18.02.
Right, exactly. What was the thought there? I mean, what is going to be the effect of that?
Mr. Roberts' stab at a petition this time would create conflicting provisions by giving different ways to legislate, and this would resolve the conflict by saying that in the event of conflict, Article 3 prevails. We're going to have another substance conversation.
Yeah, I'm not what part of the Good for Government proposal is being affected there?
Well, my aim is to clarify the charter to say that when deciding how to legislate, Article 3 prevails.
Okay. Well, what would be the effect on the ability of the independent cities like Berry Hill, Oak Hill, Forest Hill, and Belmead? What would be their ability to govern their own affairs if this passes and the authority of Metro to pass ordinances would be prevailing or superseding?
I've not heard a comment about that from Metro Legal or anybody else, or any of the, the election, the Charter Revision Commission has two former members of, or two former Metro Legal directors in the group, and that's the sort of thing that I would expect the Charter Revision Commission to have brought up if there was an issue. I haven't heard any issue about that.
Okay, all right, okay. I don't have any further questions. Does anyone else have questions? Okay, thank you, Councilman Mendes.
All right, thank you.
Okay. Yes, Councilman Glover, thank you, welcome. And you have 5 minutes, and we may have questions for you after you're done.
I'm going to take this off because I don't like it and I can't hear. So let me be very clear about one thing. I'm elected. I'm elected by the entire city to speak on behalf of the city. And I voted for this particular thing on the council because I'm not going to be a hypocrite. I'm not going to say that the people should have a voice and then take that voice away from them. I would not, I will not, I shall not do that. And so therefore, I ended up voting for this. I think that a legitimate question was brought up, Mr. Chairman, in that this one is condensed into one, while the other is condensed, or not condensed, but broken out into multiple parts. I think the commission, correct me if I'm wrong, and by the way, thank you for allowing me to come and speak. I appreciate everybody volunteering their time and doing what you're doing right now. But I think the commission asked, on the last petition, if it was done properly. And then kind of got batted back and forth, et cetera. Now, apparently, the people have signed it. The people want to vote. The reason, and this is a very important, what I'm about to say right now is the most important thing in my mind. If this council, if this mayor would have listened to all of the people, we would not be here right now. But we are because of a massive, massive tax increase. And so this is the people saying, we've had enough. We want to have a voice. That, in my mind, is the most critical point of all of this. And that is why I ended up voting for this resolution on the council floor. Yes, it was unanimous, absolutely. I can't say I want to let the people vote and then not let them vote. But I don't think we're allowed to make it so confusing that they don't know what to do. Now, here is another point I think it's critical. I'm not certain why you didn't get this resolution from the council till this past Friday, but I believe, Mr. Chair, you can tell me, I think sometime in either March or April, you got the petition from Mr. Roberts, and you've had the time, I think, Director, I think you have, gone through, counted all the signatures, you and your staff, and determined it's correct. You just got it from the council. I think it's vague on how the numbers work. But apparently we're flush with cash in Nashville these days. And so I don't know that you have to have it on the same ballot. I think it's confusing. I think the people of Nashville want to have a voice. And I think this was them reaching out and telling us they want to have a voice. And it's up to us to listen and determine. I mean, I think if I understood correctly, you voted to put this on the ballot. I think you're looking at the date. Is that correct, Mr. Chairman?
Yes.
Thank you, sir. And so you're looking at the date. I don't know that it has to be the same date. I think state law, and by the way, I'm probably the only one who's not a lawyer sitting in the room right now. But I will tell you this much, I'm elected by the people, speak on behalf of the people, and that's why I'm here. And so with that, how you do this is certainly your decision. And I will echo what Councilman Mendes said. Thank you for your service. It is volunteer. You've spent more time than you really would prefer to do, I'm certain. Forgive me for my voice being so raspy, but pollen is just tearing me apart right now. But with that, I think it's important to know that the people who elected me asked me to make sure they get to have their voice heard. With that, I close.
Okay, thank you. Any questions, commissioners?
Councilman Glover, thank you once again for coming, and I appreciate all that you and Councilman Mendes do for the city. Thank you.
Thank you.
Just want to ask a couple questions, and I ask my questions for clarity and understanding. So, in your opinion, does let me say the first one here. Do you think that 837 has issues, in your opinion, that has legal questions?
I think it does, yeah.
Second question.
And if you don't mind, Commissioner, let me finish answering it.
Please.
I didn't do a very good job of that. I think we combined it all into one. We did exactly what Mr. Roberts did in the first petition, and then we threw it right back out here to put out on the ballot. So I think we put you in a quandary that we shouldn't have. So I believe, yes, I think there's some questions with that.
Okay, so since you said that, to use your words, it's combined like the first petition that was
That
done.
Mr. Roberts did.
So would you be of the mind that it needs to be resolved or fixed, amended in such fashion as his second petition?
It is my opinion, I believe it should be. Yes, sir.
And is it your opinion that it should be on a different ballot?
Yes, sir. I don't think that if you set the date today, that you've been given sufficient time to deal with the complexities of it. And so therefore, that is why I think you should be able to do that. Yes.
All right. And if you so choose to answer this one, I'm just asking because you brought it up. In the issues of getting this information 17 days late, do you have any reason to know why this commission got that information at such a late date?
No, sir, I don't. That part, I agree with Councilman Mendes on that. I have no idea why you didn't get it because it should have flowed a certain way. And I don't know if I would say who's to blame or whatnot. But even still, the more important issue I think is that this was worked on when Mr. Roberts brought the first petition and the commission debated that. This has been worked on for a very long time, and it was only brought back on for the council to vote on when it was apparent that Mr. Roberts' petition had succeeded and was written properly and would give the people the opportunity to vote and make their voice be heard. So I'm sorry if I was long-winded on answering that or if I went a little outside of the scope, but I think that's extremely important.
I have no further questions, Chair.
Any further questions?
I have questions, but not for Councilman Glover. Thank you. Apologize for my sneezing, but Colin, I'm right there with you.
Now, I got you.
Councilman Glover, thank you very much.
Thank you, Chairman. Commissioner, thank you to all of you guys for your work and for what you do. Director, thank you.
Chair, may I approach this
Sure.
for a quick point?
Yes.
I just want to point out that in Section 2 of the resolution we passed, we very much didn't want to cost the citizens of Davidson County a separate election. And so the language of the resolution says specifically it can only be on the same date, otherwise the resolution's null and void. So putting on a different date is basically, I don't know if you can put on a different date with the terms. I'll leave that to people who are being lawyers here today. I'm just a councilman. Right. I just want to mention that. Thank you.
I do have a question. Did you consider whether or not we could put it on a date with another election, combine it with another election so as to save money that way?
I don't think there's another election till next May.
Correct.
Did not think about that because no elections till May. So no, didn't think about it.
Okay. All right. Thank you.
Thanks.
However you approach.
Yes. So far as I'm concerned, unless the other commissioners object.
It was not placed on, on our vote with that discretion. However, I think the discretion is clearly here with you. And I also think that the way it was written does throw it all into one lump that will completely invalidate the petition the people signed that they want to vote on. So I agree with the fact that, yes, it was asked to be put on the same date, but legally, I don't know that state law or the charter would make that actually happen. Thank you.
Okay. All right. Unless the commissioners object, I'd like to get some input from our lawyers who have not had very much time to look at this, but at least they've given it a very quick once-over. Is that acceptable if we ask Mr. Blumstein to speak a
Sure.
little bit?
Briefly.
Professor?
Thank you for, all I can say is thank you, I guess, for asking me to weigh in on this. I agreed to do that if called. This is difficult. It's a difficult issue. The commission just got this last Friday, and I think the letter that I saw wasn't even dated. It was not properly dated, if I remember right. It was dated sometime in September rather than in May. Is my recollection right about that?
Yes, it's sometimes the cover letter said September of 2020. I assume that was a mistake. Perhaps that letter was used from something that was done last year, but we did receive the certification on Friday the 7th.
Yeah, that's what I was told. That it came in on Friday, but it was when I saw it, it was dated a different date.
Right.
This is difficult. We've been spending 6 weeks, first in phase 1 for me, and then phase 2, both Austin and I, and really working hard on trying to get the framework right. I think last year's petitions, I've called them a mess. I know the author of the petition is here, and I'm sorry to have to say that, but I think it was. But I think also that they learned on this. They didn't appeal Chancellor Lyle's opinion. They went back and drafted it in accordance with her admonitions and came back and got a much better product, one that the commission, I think correctly, has voted to put on the ballot. There are significant questions about this Metro petition. I am not in a position to say at this point what the commission ultimately should do. What I can say is that it's not ready to act. I'm not ready to recommend action. I think we have to, as lawyers, we have to go back and think about this. One of the things I would want to look at, and especially when you have the same format that was thrown out last time, all linked together, I have concerns about that. But whether it's legal or not, I can't answer that. I would want to look around. Chancellor Lyle cited some law review articles, and look around. Other states do this kind of thing to see what the precedent is, what the meaning is. So I have both, in some procedural and substantive concerns at this point that are worthy of further commission deliberation. On the procedural side, the For Good Government Group has filed its petition. The commission quite properly asked Dean Koch and Director Cooper, General Cooper, both excellent lawyers, to provide their analysis, which they've done. Metro has an opinion that they've put out. I think that's the right thing to do. I think we should give, since this is targeted at the For Good Government Group, I think basic fairness suggests that their lawyer, Mr. Roberts, Jim Roberts, be given a chance, a week, 10 days, something, whatever you think is reasonable, to analyze and provide a critique of this proposed Metro Charter amendment. And then I think Metro Legal should have an opportunity, a week, 10 days, to respond. And Austin and I would then be working with their responses and our independent research to figure out what we think the right answer is. And that, to me, is the procedural point. And to clarify whether voters can vote for each provision separately or whether they're all together as part of one kitchen sink. Now, if it is, and Mr. Mendes has said that he thinks it is one amendment with lots of different parts, amending many different parts of the charter. Well, it's not clear to me that 1901 allows for that. I'm not ready to stand here and say it doesn't, but it concerns me, and I think we need time to focus upon that. And I think the commission, frankly, needs time to focus upon that. And then, in addition, if there's a violation of 1901, there's a separate question of whether the commission has the authority to act on that, or whether that would be a legal conclusion which would be beyond the scope of its authority. And then the commission would have to consider whether to file a declaratory judgment action to clarify in court what the legalities are. And so I also think that there's a fair question. Chancellor Lyle said that ballot integrity requires that the voters know what they're voting on. I think it might actually have been clearer to say whatever is done in these 6 amendments is undone in this amendment, yes or no. That would be clear. I'm not sure that I'm ready to make a bottom line conclusion, but it concerns me. And I don't think, my preliminary thought is that that's not within the scope of the commission's authority. But if it's troubling to the commission, it has authority to go back to court and get clarification on that. And so whether the form is appropriate or not, I think that that this is a serious question. The lumping together, the explanation in 200 words, what's going on, if each one was separate, then there would be a possibility of either just letting the language stand by itself or having clarification. It depends, as I remember, it's a 300-word threshold. So the 4 good government provisions, are they 300? Each one is separate. Will each one be 300 words or not? I haven't counted the words, but my preliminary indication is that none of those is 300 words. So there doesn't have to be a summary for those. They'll just go on the ballot with the text. I haven't checked to see, certainly the Metro provision, if they're not separate, would be more than 300 words, and then you have to boil it down to 200 words to explain what's going on. And I haven't seen the draft language from Metro Legal to determine. So my bottom line is, Mr. Chairman, I don't see how the commission is ready to vote at this point. I'm certainly not ready to opine about this. And so I think there's a procedural dimension and then a substantive dimension, neither of which would allow the commission to move forward at this point. And so that's kind of where I come out on that.
Okay. All right.
I just want to.
Commissioners, you have questions for Professor Blumstein?
I suppose, because I think he's our lawyer at the moment, and I know you haven't really had an opportunity to go through all this yet, so I'm just kind of making sure I'm understanding, because I think we're talking really fast and really technical past each other. But are we getting the impression that this is one amendment versus separate amendments? It says each amendment in the summary. Is that just based on, Councilman Mendes said it's supposed to be one amendment? Is that the difference?
Well, if you're asking me my opinion, I thought that it was one amendment when I read it, and when I asked Councilman Mendes, he confirmed that. So it does appear to be one. The severability clause is a general severability clause.
Versus each, which is what, I just want to kind of pare it down to what like fundamentally is our big issue right now. And that is that this amendment has been produced to us. You had the impression it's one amendment. Councilman Mendes said he thinks it's one amendment. But the summary, it was written by whoever, says each amendment, and that's kind of the rub here.
But it's one summary. So if it were 8 separate amendments, it would have 8 separate summaries.
But I'm not trying to advocate for one position or the other. I just want to make sure I'm identifying the problem. And so the major concern is, do we know if it meets the form requirement to even appear on the ballot? Because we don't know from looking at it if it should be considered as one amendment, which gets a certain set of rules, versus 8 separate amendments or however many separate amendments, and that gets a separate set of rules. Am I correct?
And Commissioner Hertzfeld, in addition, under our analysis, we would have to think about whether
I
the
understand that. I
commission has that
absolutely-
authority to do that, or whether a court
Professor
owner-
Blumstein, and I don't mean to interrupt you, I completely understand what you're saying, and you haven't had an opportunity to go through all that and to kind of do the pick through. So I am not wedding you to any decision that you're,
No, but I
to
think,
anything
I'm
you're
just saying
saying.
it's even more, you're making the right points, but I'm saying even what you're saying is more complicated because there's a separate question whether the commission can act or whether it has to go to
Hadn't
court.
quite gotten there yet, right? I think we're thinking on the same wavelength. So I just wanted to be clear that, like, as our threshold issue from a procedural matter, that's the confusion. Is this one amendment that goes by a certain set of rules, or is it separate amendments that go by a separate set of rules? So that is question number one, and I think we're also going to get, perhaps, I'd like to hear from Director Cooper as well to see if he has an opinion on that. And then secondarily, going through and teasing it out, there may be some issues of form, some issues of substance, some things about whether they're appropriate or not. But you and Mr. McMullen haven't had an opportunity to go through that yet because you've just gotten it, and you would like some time to do that. Am I correct?
Yes, that's correct.
Okay, perfect. I just wanted to make sure that I kind of understood the lay of the land and where we were. And so if we're all in kind of an agreement, if that's where we are, I think then I feel a little bit more comfortable just to understand who the players are, what the issue is, and why it is that impacts what we do.
Okay. Are there any other questions for Professor Blumstein at this time? Okay. Commissioners, is this a time to talk, discuss, any comments?
I would actually like to hear from Director Cooper on this issue,
Sure.
if we could.
Okay.
If you're prepared, I don't mean to be calling on you if you're not prepared to answer. This was not something that I think you were probably prepared on today. So if you're not and you want to take a mulligan, I understand that as well.
No, well, what exactly is the question?
The question is, do we know if this is one amendment or multiple amendments? If Metro Legal has an opinion on that, it appears to be there's a question based on Chairman Delanis' understanding of what it is, and apparently what Councilman Mendes may have said when he was speaking versus the summary which says each amendment.
And let me say, this is not based on a lengthy analysis of this, but the summary refers to this amendment. The resolution refers to amendment number blank. And then for the ballot refers to the summary refers to this amendment. So it would appear that this would be placed on the ballot as a single entity to be voted up or down as a whole. And that is an aspect of amendments that is generally left to the drafter, whether it be by petition or by council resolution, where multiple provisions are grouped together to be voted on as a whole or broken into separate pieces. And there is nothing intrinsically wrong with that process. It does raise, obviously, questions of severability, as you have noted before, and those questions of severability came into play with the 2020 For Good Government resolution, which was presented as a whole. But mainly, it's a question of how this is presented to the voters.
And I have a question just kind of as procedure, and perhaps someone can help me out because I haven't ever done this through council before. If there needed to be made a change to a word or a phrase to clarify that this is one amendment or multiple amendments, does that have to go through and get re-voted on all the way through council?
Well, I suppose only if there is ambiguity as to how this is presented.
Okay.
But I believe we have the sponsor here who can certainly speak to what the intent, and if we view the language as consistent with that intent, it would not appear to need to be modified.
Okay, thank you for that. I do have one more question then for Councilman Mendes, if anybody doesn't mind. Hi,
Yes,
Councilman
Commissioner?
Mendes. Thank you so much for coming back up here. And thank you for the indulgence of the other commissioner members. I just want to make sure that I understand what's going on here, and I try to follow these things pretty closely, and I even get confused from time to time, and I'm a little bit confused. So I want to make sure that it's correct. I'm looking at what is number 4 in our petition packet.
And I don't have a copy of exactly what you have.
Could we get a copy for,
Thanks, Professor.
thank you.
All right.
I think if we're all kind of on the same page, perhaps it would make it. So I'll note by, if you don't mind just looking at number 4 with me, it has number 4 in the first corner. I am a little bit confused, and I guess this is actually, I'm going to ask this of our staff. It says that this letter is dated September 16th, 2020 from the Metro Clerk, but I'm assuming that that is a typo, considering she is referring to things from April 20th, 2021. Okay, is that right?
Yes, Commissioner,
Okay.
that's our assumption also.
Okay, and so then flipping through here, just to show what's in this packet, because I think that's what matters kind of for the public to understand, is we have amendment number 2 to the resolution, which is adopted April 20th, April 6th to the resolution, amendment 1 to the resolution, which is adopted April 6th. And then we have the resolution, which is voted on by council, but that's not what actually ends up on the ballot. There's a summary that ends up on the ballot. Is that right? Can anybody answer that question for me? The entire thing ends up on the ballot, but the summary is what's at the top. Correct. So it says, so for the public, when you're going to vote, it'll say, here's the summary and this is what this stuff does. And if you want to see the actual language of what it is, because you're like me and you like to look at it all and see if it's a shall or a may or a must, you can go ahead and look at all this individual language underneath. I'm assuming most people probably breeze past that, but they're both there on the ballot. Is that right? Okay, and then Councilman Mendes, you had talked before about the work that you put into this, and it does all these different sections. It says here in the information for the ballot, it says this amendment, that's one amendment, and that's what you said was your intention, is that right?
Yeah, are you looking at the page that's got the signature at the bottom?
Yeah, the one that's got your signature, right, that one right there?
Yeah, right.
Yeah, okay, and so that was your understanding when you were the drafter and the sponsor of this?
Right.
Okay, and do you know why it says each amendment when it's talking on the resolution summary?
You've mentioned that a few times, and I don't know what page you're looking at.
Okay, I've got my notes on it right here, but it says, the one that says legislation resolution RS 2021-837.
Yeah, I mean, I know practically exactly what's going on there.
Okay, good.
So
Could you explain it, please?
The Metro Charter lets the council put things on a ballot twice per term. So longstanding practice is that when the council brings items to go on a ballot, there are multiple changes that go into a single amendment. And there have been times, I understand, where it's been pages and pages and pages that has been put as I know was confusing to council, but it's been done many times before where it's just an up and down on the entire set of changes in a single amendment. And so the custom and practice, as followed by the council, followed by the election commission many times, is that many changes to the charter are in a single amendment. That is I think the reference to each amendment, but clearly, as Legal Director Cooper pointed out, the text of everything in the body of it, including the summary for the ballot that you were pointing to on the page with the signature, is drafted from the perspective of it being a single amendment. That's the way Chair Delantis read it. That's the way it was intended. Matches previous custom and practice.
Great, thank you so much. That clarifies it for me. Thank you so much.
Thank you. Thanks, Chair.
Mr. Cooper, I have a question. Have you written a opinion, or has your office written an opinion concerning this Resolution 837?
There is no public opinion that the office has issued on this resolution.
I understand it's not been made public, and I'm not going to assert that if you tell us one exists that makes it public, but has your office issued an opinion concerning this 837 resolution?
I'm not aware of any written opinion we have issued on this.
Okay.
Mr. Chair, I don't want to interrupt your meeting, but may I speak to the question that was asked a moment ago by one of the commissioners with regards to the council vote? And if not, that's okay, but I just think to hear it all is an important thing.
Briefly.
It'll be very briefly. I voted for it because I felt like it had the same complexities of what Mr. Roberts did in his first resolution that he brought from the people that they signed. I thought it had the exact same flaws, and that's why I voted for it. And I'm glad, frankly, the question's been raised. Thank you.
All right. Okay. Is there any further discussion of Resolution 837?
No, I don't think I have any other questions.
Okay. I mean, we've heard from our lawyers and more than one lawyer, and we've had a lot of comment on it.
Actually, Chair, I apologize.
Sure, you do. Go ahead.
I do have a question, and I apologize. I got a little hungry. I just texted my husband and asked him to make sure he'd save me a little bit of dinner because we've been here for a bit. I do have a question about an obligation to put this on the ballot. I mean, we have an obligation to put it on the ballot at some point, or to vote, or it has to go along. And I understand wanting to get more legal advice on this, but what I don't want to have happen is have this amendment, if it is okay, get away from, it's supposed to be tracking this other amendment according to its own text. So I'm not exactly sure how to handle that.
I understand. I think we've been put in a difficult position.
I don't know that I think it's difficult. I think it's just a bit of a scheduling issue.
Well,
we have 70.
I won't quibble with the word difficult, but I don't think, personally, I don't see how we can vote on this today. I do think, obviously, we have an obligation to consider it, and we're doing that now, and I think we have to do so as quickly as we can.
If I could just ask a clarifying question. So it's the day, I want to make sure that I understand this, and perhaps the administrator here can help me out. So the day we vote on to whether something goes onto a ballot or not onto a ballot is the day that starts the 75 to 90 days ticking. Is that right?
That's correct.
Okay, and so we've already voted to put onto the ballot the For Good Government petition, and so that starts the clock today for the 75 to 90 days. Is that right?
That's correct.
Okay, and those two dates that you've given us, which we'll get to on item 5, are either July 27th or August 3rd, and those are both within that 75 to 90 days?
That's correct.
Okay, and July 27th, do we know which date that is, and August 3rd, which date that is?
The July 27th would be the first date. That'll be a Tuesday. August 3rd would be the last date, a Tuesday, within that 75 to 90-day window.
Okay, and so there is a way, I just want to make sure from like a calendar perspective, that there is a way we could go ahead and set the election today for the For Good Government petition. And if we needed to take a minute to get some legal advice as to whether or not the Metro Council amendment were to go forward, proposed amendment, we could set that so those would both hit within the 75 to 90 days. They could both appear on the ballot if we voted and found it appropriate to do so. Is that right?
That's correct. If you choose the August 3rd date, that would allow a few more days to consider the 837 resolution.
Okay, and so Chairman Delanis, I don't mean to be pushing forward to item 5 yet, because I was the one that asked to consider item 4 before we got to item 5. But I will just give you a tad bit more information, which may be helpful, is that I am supposed to be in Northeast Tennessee, as you all know, because that's where I go all the time, for a jury trial that is supposed to start on July the 26th. Which makes July 27th, considering I'm statutorily supposed to have to be here for the election, like absolutely impossible for me. Now, August 3rd, I think there's a pretty good chance that I could be finished by then, or, things could have changed. And so I think August 3rd is a possibility for me, but I should just tell you for purposes of scheduling and what it is that we're doing, that July the 27th, it just is like I absolutely cannot change that trial date.
How long is your trial scheduled to last?
It's supposed to be about 2 weeks, but I don't actually anticipate that it will go the entire time. So, what I'm happy to do is set it for August 3rd. If I know for a fact I will be in on the 27th. Like that, I absolutely 100% know. If we set it on the 3rd, I could drive back, do my statutory obligations here for the Election Commission, miss a day if we're still in trial, which I don't think we would be, and then come back. Now, if we could set it after that date, after the August 3rd date, that may work as well. But I definitely can't do July 27th. And I'm actually going to be in Northeast Tennessee kind of leading up to that. I hate to throw that wrench in, but before we make any decisions, I just thought it was best to give you that information.
Yeah. Okay. Ordinarily, we accommodate everyone's schedule, but it sounds like there's no guarantee you're going to be able to be here on August 3rd either.
No, but I'm telling you, I do believe I will be able to be here on August 3rd. I do not see that as being a problem, but the 27th, I know for a fact will be a problem. I think I can make arrangements on the 3rd is what I'm saying. I definitely cannot make them on the 27th.
Okay. Well, I guess I need to think about the ramifications of pushing this election 1 week.
Are we within the 90 days if we do the 10th? We're not, we're outside.
No, we're outside. Then we're outside, and we like to do them on Tuesday. Yes, Commissioner Davis.
I have a question. In concern with everything from all parties involved, and I'm asking the question, the later you push it, does it not jeopardize all parties involved for the things that they're asking for the people to do?
Well, yes. We are in a bind, and of course, we don't know whether there's going to be litigation either, which may throw all of this into a clink.
And then second questions, are we, as Councilman, as Commissioner Hertzfeld said, we're all legally bound to be here on the date set, correct?
Right.
Regardless.
Wow.
Is that not correct, legally?
Wow. That's a hard question to ask a fellow lawyer. I don't know what to say about that. That's a tough one. It does seem to me that might give you grounds for a continuance, but I wouldn't want to be in your position either.
It's not that type of a case. I'll just say that I do think.
Yes. Do we have a thought?
I was speaking.
Okay. Yes.
If you'll just let me finish. Can I finish?
I'm sorry. Yes,
If
go
I could
ahead.
just finish my
Yes,
thought, I
sure.
would appreciate
I'm sorry.
that.
Yes.
Thank you. I would just say that I do think, we have always tried to work with each other's schedules, and I believe I've tried my hardest to accommodate everyone else's schedules when we can, whether that be evenings or Saturdays, and I'm happy to look at any other dates. I'm happy to do it. I wouldn't bring this up if it wasn't absolutely, I think you all know, I've had one case in particular I've been working on for a very long time. I just don't have any flexibility there. And I have to tell you, I would be, I would take it as a point of personal privilege if we could all extend that courtesy as we've continued to do on this commission for the, how many years have I served now? 8, I think I'm on my 9th. If we couldn't do that, I think it would just change the tenor of the collegiality that we've had here. And this isn't for tactical reasons, it's only because I literally have a jury trial that I cannot move.
I understand. Okay. Yes, you're recognized, Mr. McMullen.
Thank you, Mr. Chairman. I just wanted to bring to the commission's attention the full text of the statute that I believe is being referred to, which is Tennessee Code Annotated 2-12-112, that refers to the members of the County Election Commission being in the commission office throughout each election day unless they are out for good cause. And so I just wanted to bring that language to the commission's attention since this seemed to be a question that was being discussed, and whether, having to be out of the county because of a work-related jury trial reason could potentially be good cause. Thank you.
I am getting some information from Mr. Cooper. Do you have a? Thank you. I don't have my statute book in front of me. Thank you. I don't think it was 112. Do you know what the statutory site was? Would you mind repeating it?
2-12-112.
Dash 112,
Yes.
120,
112.
112. Okay, so I'm looking at 112, and it says, in any county having a population of not less than 825,000 or more than 830, are you looking at the same section? Unless they are out for good cause, here at the bottom. The members of the election shall be in the commission office throughout the election day unless they're out for good cause. That's the section, that's what you're talking about?
Yes.
Okay, good. It's the last section of that. And I'm being told that that's not the population of Metro government. Do you know what the population of Metro government is? I don't either.
There's a lot of things I know, and there's a lot of things I don't know, and that's definitely one of the things I don't know.
Okay, it's not me either. But regardless of getting into technically whether we could set an election on a day one of the commissioners is absolutely not going to be here. I mean, I know that there are legal things that we can do, and then there are just things that we do as colleagues. I would just ask, I think I've tried to be very collegial during my time on this election, and I hate to ask a favor, but I would ask a favor.
I understand.
I mean, I've never missed an election. I think it's part of my duty to the taxpayers, and I'd like to be able to be present, even if legally I can get out of it. And I appreciate the sentiment there.
Mr. McMullen found that section, and it depends on the population. But then the question is, if it's not applicable, Commissioner Hertzfeld, if that's not applicable, what is that? If that section isn't applicable, what's the default position? I mean, we haven't researched this, so I don't know. But
I appreciate that, Professor
what's
Blumstein.
What's the default position?
I don't know. I'm just asking for collegiality, right. I think. I don't know what the default position is and legally what it is, and I suppose we could just, argue about that ad nauseum and write opinions on it, but really I'm not trying to keep us here all night. I'm just trying to say I have something I can't be there, and I would ask my colleagues to, right. Please put aside any particular bent or partisanship or any, particular thoughts people have, and to continue with what has been our long-standing tradition of trying to make sure that we can all be present. That's all.
Okay. I don't, Commissioner Hertzfeld, I don't think it's any thought to inconvenience you. It's just that I think that there's going to be an argument made that this has taken too long, and that the Metro's budget has gone too far forward, and that if this provision passes, then it will be of no effect. So I think you're absolutely right that we always work to accommodate everybody's schedule, and I would suggest we continue to do that. So, I mean, I hope you don't think that just because we're considering doing it here, that there's any thought of a lack of collegiality. It's just that this is a billion-dollar issue, and we're being told by many people that unless we get it decided by a certain time period, the issue will not be effective. So that's just a comment. It's not any indication that I am, at least as one person on this commission, unwilling to agree to your request. So
And like I said, I will bend over backwards
Sure.
and make the August 3rd date work. I know that's the other date that's been proposed, and I will make the August 3rd date work. You will not hear me saying otherwise.
Now, if we do that, then, I mean, I think we have to have a schedule to consider the resolution 837.
Yes.
And I do have a question for Mr. Cooper, and that is Metro Legal anticipating preparing a summary for Resolution 837? And if so, when can we see that?
We are happy to look at that and get that, if we need to prepare one for you, to get it to you on a timely basis.
Mr. Chair?
Yes. Yes?
If we were to set the election for August 3rd, or for August 3rd, wouldn't that give us a little bit of time to get various legal opinions from folks before we were to vote on the Metro Council resolution if we chose not to do that today?
It would give us one more week, yes.
Question.
It would give us more time, yes.
Question.
Yes, Commissioner Davis.
But according to Metro budget and at the start of fiscal year, I believe it was on the 1st, how does that impact? My question is, if it is pushed to August, how does that impact the issue of the Metro budget in regards to these issues that are being discussed? Right. And so in turn, is this going to cost the taxpayer more money and other issues?
Right. Professor Blumstein, I think there's been some talk about an October 1st deadline and a 60-day period. Could you cover that for us again?
As I understand it, Mr. Davis, Commissioner Davis, sorry, it all turns upon whether Metro is a home rule city or not. If Metro is a home rule city, then the effective date is 60 days after the referendum election. And so that's one date, one thing to keep in mind. The second is Chancellor Lyle stated, and the law in Tennessee is pretty clear on this, that a charter amendment cannot undo an adopted budget. But the date for undoing is the date of the due date for the taxes, which is the first Monday in October. It's not the date that they actually pass the budget, but it's the date that the taxes are due, which is the first Monday in October. And if this is pushed till August, I don't have my calendar handy, but would that allow, when is the first Monday in October?
October 4th, Professor.
Okay, and would that fit within
August 3rd.
3rd, would that, let's just ask Jim Roberts, can that be done? Will you know the answer in time on the day of election, or will it be the next day?
I think we've typically always known. I think even in the presidential, when we had all the write-in ballots, we still knew the night of. I was very proud of us for that.
I
We
think
managed
the
to process
issue-
all those.
I think the issue can be avoided if, in fact, you meet the 60 days, then there's not an issue. Now, Metro has not definitively been determined to be a home rule city. So I'm guessing that the For Good Government group will certainly claim that Metro is not a home rule city, and if they win the charter amendment, that it becomes effective for this budget cycle. I also think, and here I'm going to direct this to the two members of the council who are here, is that what they can do is that they can prepare alternative budgets. So that what would happen if this passes and it passes in a timely manner? How would they do their budget in such a way that it reflected the passage of this amendment? Or they don't have to, that's just up to them. But I think that would be the prudent course, is to have the budget on a two-tier track. But the 60-day window only applies if it's a charter city. That's my understanding, right, Austin? I'm sorry? Home rule city. And so if you don't meet the 60-day window, there's going to be litigation. If it passes and then Metro argues or someone argues that it doesn't meet the 60-day window, now what we could do is...
Professor Blumstein, it looks like if you count the 60 days, that actually becomes August 5th. So we're talking about having it on the 3rd. So depending on if you count the day of and you know how lawyers count, it would be the 4th at the most conservative, but truthfully it would be the 5th, and that would put you within the 60 days. So that should blunt any concern about whether there's going to be an argument that
if that's
Metro's the
true,
home
then this
rule.
issue goes away.
Right, then that issue goes away. So it sounds like perhaps we could, in keeping the integrity of all these things going on, do August 3rd, give ourselves a little bit more time to get some legal advice, and then, vote it along. But,
Chairman, may I ask,
I wasn't quite finished speaking.
I'm
but
sorry.
Thank you, that's okay. So, I appreciate your input there. I appreciate some quick calculations that people are doing to make sure, and I really appreciate you anticipating the potential legal arguments, because I think that that's really smart to do on the front end, so we can kind of figure out where we're going to be. But I would appreciate if my colleagues would consider my request as a point of personal privilege. Thank you.
Chairman, may I ask a question?
Yes, certainly.
If I may I call both councilmen up to the podium for a moment, just to ask one question? Is that permissible?
It's okay with me.
Both councilmen, would you
Absolutely.
please come to the podium for a moment?
It's,
Council, I need to ask him one quick question, if you would. I need him to come to the council, to the podium.
Mr. Chairman, I just wanted to say it's Article 11, Section 9 of the Constitution that applies to home rule cities and has that 60-day effective date period and so forth. But again, I'm not advising the commission what to do in this regard. The concern that I have, however, would vanish. This particular concern would vanish if there's time to meet that 60-day requirement. That's all. And I think that
Appreciate that, Professor Blumstein.
yeah.
What happens if the results are challenged, election results are challenged? What happens that 60 days at that point?
Yeah, and the commission still can set the July 27th at a later date, because that still fits within that time frame. So, I mean, if there's a concern, that can still happen at that point. So if the commission chooses not to set a date, it can choose not to set a date looking towards either August, August the 3rd or July the 27th. It can choose not to set a date, and we can look at this further. But I think the problem that I identified doesn't really happen if there's 60 days at the back end. I think that Commissioner Hertzfeld is right about that if there's 60 days. Now, there is a question, there's a tactical question, and that's something that
Professor
staff
Blumstein,
would have to.
and I appreciate that. The 60 days, do you know if that goes from the date of the vote or the date that the election is certified?
Austin has the text. What?
The text is, such proposal shall become effective 60 days after approval by a majority of the qualified voters voting thereon.
I hear that as certification, actually. But that's an open question, but I think typically when we're talking about, whether voters have approved something or not, typically that's when we've certified, not necessarily when people have voted.
Yeah.
Because, things get close sometimes.
And we don't know what the consequences are. So, I think all of these, I'm trying to avoid problems.
Understood and appreciate
I'm
that.
trying to do. And the 60-day thing may not apply because Metro, the only case that I've been able to find, and we haven't spent a lot of time on this, there may be others, there's dictum in a Tennessee Supreme Court case that says that Metro is a home rule charter city. There's dictum in a case out of Knoxville. Dictum. I can't say that's binding or holding. There's an assumption. But then when you look at Metro's position in the litigation on the education savings account, Metro was careful not to claim home rule status in its complaint. So I'm guessing that Metro will take the position that it's not a home rule city, and then the 60 days don't apply. But they could take the position, because there's some dictum to that effect, that they are a home rule city. So I think it's just prudent for me to bring that to your attention, that that's a potential issue out there. But if you're within the 60 days, then that issue goes away. Okay?
Appreciate that. Thank you.
Councilman, one quick question. In the relevance to the people of Nashville and to preservation of their money, how hard would it be for Metro government, i.e. City Council, to make two budgets pending these issues? How hard would that be in your opinion?
I'm sorry, I was trading spots with the professor. Could you repeat the first part of your question again?
How hard would it be for Metro, i.e. City Council, for you to have two budgets ready pending the issues that are being talked about here, in your opinion?
That would be difficult. The charter lays out a pretty specific process for us to approve a budget, and it doesn't contemplate a backup budget. I think, and Director Cooper can check me on this if I'm wrong, but if Metro's revenue gets, for some reason, carved back middle of a year, the charter gives our finance director the authority to sequester funds. And so just like when after the 2019 election, the city had cash problems and the finance director basically decided what to stop spending on. That's what would happen if there was a mid-fiscal year cash shortfall. There's not really a mechanism in the charter, and again, Director Cooper can check me if I'm not right about this. There's not really a mechanism in the charter to pass a backup budget, per se.
I didn't say pass. The question was just out of the trying to be all of us good stewards of what the citizens of Nashville are asking us. I'm just asking questions just as all these issues are being considered, and since I'm sure everyone wants to know. So that's why I'm asking the question to you, both you as well as to Councilman Glover.
Yeah, it's a fair question, but the only way to come up with something that would be binding would be to pass it. And so on July 1, the first year of the fiscal year, we will have a budget. It'll either be the budget the mayor just proposed, or it'll be a different budget if the council passes a substitute in June. But come July 1, we'll have, by charter, by Metro law, a single budget. And it's, if this goes on a ballot, it sounds like it probably will, we'll have to fundamentally decide whether we preemptively enact a different tax rate because something might pass, or go with the tax rate proposed by the mayor and run the risk of having to chop expenses mid-year. We'll just have to choose one or the other.
All right, let me hear from Councilman Glover, please.
So here's how I'm going to answer the question. Last year, when we did the budget, we were told on the council floor that we would come back and reevaluate it in August, and we would have to pass something in August because by around the 1st of October, that's when the tax bills went out. We were told last year we could do that. We didn't. So to answer your question, I believe if I understand your question correctly, we can do it. It is in our authority to do it. The real question is how quickly would we get the information back? Because I think the assessor but when they send that tax bill out on your property tax is what it all rolls around. And I believe you guys said that was like 4th of October. That's the first Monday. If I remember correctly, that's what you said. So, but to answer your question, we can do that. Yes, sir.
Thank you.
Any further discussion on that issue?
No, Mr. Chairman.
Mr. Chairman, my co-counsel said he thought he heard that there was a disagreement whether it's the vote of the date of the vote or the date of the certification of the vote that controls. And this all may be just abstract because it may be that Metro is not a charter city. I'm trying to avoid that litigation issue. But if it's the certification, then that does cause me concern, Commissioner. I had assumed from the reading of the language that it was the date of the approval, and then you'd have that flexibility. Let me suggest there's no need to set a date today, because whether it's this July the 27th or August the 3rd, you'll still be able to set that. Mr. Roberts, is that right? You're still able to set that at a later time as long as it's within that 75 to 90-day period. Is that right?
That's correct. The commission would have to set a date to have another meeting to work within that 75 to 90 days and fit within the 27th or the August 3rd.
So I certainly understand all these factors and certainly maintaining respect for each other's schedules is an important value in any communal group. Can't interfere, in my opinion, with the legal outcome, but we don't know what it is yet because we haven't had time to look at to see what the right date is. I had thought it was the date of approval, but if it's really the date of certification, then I'm worried about that. And so I think we don't know the answer to that. I don't know that. Reading the plain language, I thought it was date of approval. Okay. Oh, you need to set the date today. Oh, is that right? Today I may be wrong about that. Co-counsel reminds me that July the 27th is 75 days from today.
78.
78. And so if you're going to use July the 27th, it has to be today. So you can't put it off if the 27th is going to be an issue. You have to make a decision. Unfortunately, we don't have the answer to whether it's the date of the approval itself or the date of the certification. And thank you, Commissioner Hertzfeld, for raising that. I had assumed that it was a date of the approval because that's the plain language. But if it's date of certification, then that becomes a potential problem.
Okay. Commissioner Hertzfeld, is there any chance that if we put off the decision to set the election day, put that off several days, that you will be able to approach opposing counsel and the court and ask them whether they could postpone the first day of your trial 2 days?
There are too many parties involved in the case. It's not going to move. But I am.
Decision, you can't do it on the 27th, you got 3 days. So
It,
we have to decide today.
if it's the 27th, I just won't be able to make it, and I would be disappointed, but, you know, if that's what the commission decides, then that's what the commission decides.
Again, I'm sorry, but co-counsel has reminded me that there's a question about, and Commissioner Hertzfeld, we have to go back to this discussion. It may be comedy, but now that there seems to be a substantive issue, what the default position is. If this statute doesn't apply to Metro, then what actually does apply to Metro? Is there a requirement that a commissioner be physically present? I'm just asking that as a question.
Professor Blumstein, and I really appreciate it. This isn't an issue to me about whether I'm required to be here legally or not. I'm sure nobody would sue to force me to be here. I would hope not anyway. But, you know, regardless, it's not about that, and I hate to be making such a fuss out of it. That's not what I'm trying to do. We just normally work collegially around each other's schedules, and I was just making that point that I'm not available on that date. But I really also don't want to keep everybody here for the next 2 hours debating it. So if the commission just wants to go ahead and set the date that you all feel appropriate, I mean, let's just go ahead, because I think we have to set the date in order for it to be ripe for a challenge anyway, and I'm sure there are all sorts of people who are waiting to figure that out.
This is Chairman Delanis. In looking at these various dates and listening to everything that we've been told, there is certainly a chance that Davidson County will be found to be a home rule city, that the 60-day provision will apply, and there's a chance that somebody will say that certification is what's necessary, not just the election. And if we choose the July 27th date, that would give us 9 days to certify, which I understand is at least potentially possible for us to do. And there's also a very good chance that none of this will come to pass because we'll be engaged in litigation. So, and I think you're absolutely right that we all try to work with everyone's schedule. But we do have a question where this is a very big issue to the people of Davidson County, and if they vote in favor of this, and our accommodation to one commissioner means it's not effective for another year, I think that's going to be tough for at least this commissioner to live with, and I'm very sympathetic because I'm a trial lawyer just like you are. At least those are my views on that.
Commissioner Delana?
Yes.
I would like to point out that I think if it is from certification, that still won't make the 60 days on the July date.
No. I believe that gives us 9 days to certify. If we set it on July 27th, we can potentially certify in time to meet that October 1st deadline and the 60 days. At least those were my calculations.
You would have 8 days
Well,
to certify.
okay.
You would need to certify on the 4th so that you would have 60 days running by midnight on the 4th.
With that, is there any further discussion? I hate to belabor this, and this is a tough issue for everybody, but is there any further discussion on this issue?
Chairman,
Yes,
if
sir.
we went to the August 3rd date, that would put us behind. Are you assuming that Nashville is a home rule state? I mean, is that a legal opinion, or is that just?
That is from our lawyer, is a possibility. Yes, I mean, it's either home rule or not home rule, and there is some authority to that effect that we are home rule. We have Mr. Cooper several weeks ago saying that sometime, under some circumstances, it's a home rule jurisdiction, and other times it's not, and then he indicated he would get back to us on that. So it sounds like it's a legitimate concern that if we are a home rule city, this 60 days will have run.
Okay, but we're going on the assumption that we had gotten.
Well, it's not an assumption. It's one of two. It's not just like
Yeah.
a wild bang assumption. We've got Supreme Court dicta. We've got Mr. Cooper. So it's not an assumption. It's a real question. It's real. It's not something that somebody's just made up, though. So I'm sorry I interrupted you.
No, you're fine. I'm just trying to get some clarity on, we're talking about 1 week, and I know the clock is ticking, and I'm trying to make it, well, we've made accommodations for all the commissions to be here. Historically, we've all been here to every election. I've been on the election commission longer than anyone here on the panel, and I don't remember any commissioners ever missing any election at all, because that is our obligation. That was what I was told at the beginning, to always be present, just in case some issue did come up and we had to make a decision on something.
Is there an option to do it on a date in between those two dates?
That's tough. Do you want to address that?
There is an option that we could do it on the 29th of July, sticking to a Tuesday and Thursday. We would just have to work with the health department to close the vaccination site at where we have all of our equipment stored.
Just out of question, just since it's in the public discussion, would that same issue have to happen if we did it on that Tuesday?
No, if it's on a Tuesday, our poll officials will come on Sunday to pick up their equipment.
Okay.
If it's on Thursday, they come on Tuesday to pick up the equipment.
Okay, that's why that was okay.
But then we'd only have 6 days to certify, and I gather that's almost impossible.
I mean, the challenge we're going to have, we have to recover all the machines from all across the county. It'll take us 4 days to do that.
So
Then you're asking, we only have 4 days then to do all the tabulation. We're pushing the envelope any way we go at this point. Could it be done? Maybe, but we are pushing the envelope.
I'll make a motion to set the election on the For Good Government petition for the August 3rd date.
All right, we have a motion. Is there a second?
I second.
question. I want to ask Mr. Roberts. If the August 3rd date would go, just to make sure I'm clear, since this is such an important issue, refresh, just as a quick overview, run down the dates and the targets we would have to hit. If this August, since it's being proposed for August 3rd at the moment.
Probably the biggest dates, August 3rd, early voting would start 20 days prior to that. Mm-hmm. But the same date time frame would set for the 27th or any other date that you pick. State statute sets that 20 days ahead of time. Now, you will vote to determine how many sites we have open, what their hours are, those kind of things. Absentee ballots, we have to have the ballot prepared, the summaries prepared and those have to be approved by the state before we can make the absentee ballot available to the public. We will, as soon as you vote, we will turn on the request for an absentee ballot because we're already less than the 90 days out where you can request an absentee ballot. So we will start the tomorrow. If you vote tonight, we will start tomorrow putting the machine in gear to be prepared for August 3rd or July the 27th, whatever date that you pick.
Second question for clarity, point of order. If the the August 3rd date was taken, what type of time frame does it give your department to certify the election?
So whether or not you pick the 3rd or the 27th, we have to recover all of the machines from all across the county. That takes us 4 days to get all those back. Then we have to go in and read all of those machines to confirm what we have is correct.
And how long? And how long does that normally take you to do it properly?
3 or 4 days. So we're right at the edge of being able to do this. Anyone question anything about the ballot or the vote, any of those kind of things? Things start snowballing as to how quickly we can then certify. And certifying, the commission has to meet and vote to certify.
Okay. We have a motion and a second to set the election for the For Good Government petition on August 3rd. All in favor, say, I'm sorry?
I have another question.
Okay, all right.
As important as this issue is, the only thing that we're voting on, as for another point of clarity, is just on the For Good Government, not on the Metro Charter Amendment.
Correct.
That's the 837, I believe it is. Okay, I just want to make, before we do this, okay.
Okay. All right, we have the motion and a second. All in favor, say aye.
Aye.
All opposed, say nay. Nay. The motion does not carry. Do we have a second motion? Let me suggest a motion. The chair moves to set the election for the Good Government petition for July 27th. Is there a second?
Second.
Okay, we have a motion and a second. All in favor say aye. Aye. Any opposed?
No.
No.
We have two opposed. The motion carries by a 3-2 vote. Is there further discussion on where we go with item 4? I think we need further discussion on it. I think we probably need to discuss how we go forward with it. Yes, Commissioner Starling.
Mr. Chairman, I have been receiving quite a few of letters, emails stating that they want to withdraw their names. Mm-hmm. And I just want to make sure that the public knew we have those things and what we are planning on doing with that, or do we honor those requests to take their names off those petitions? I just want to kind of get where we are on that.
Mr. Roberts, is that something Commissioner Starling, is that something that we can discuss during the AOE report? Because
That's fine.
Mr. Roberts has been compiling those.
Sure, that's fine.
And we can consider it then.
Sure.
If we can, I'd like to try to wrap up item 4 to figure out what we're going to do with that. I mean, I have us, obviously, I think we should set a time period for people to weigh in, whether that be the people directly involved, whether that be the mayor's office, whether it be Metro Legal, Mr. Roberts, anybody who wants to submit something to us. I would think we would set a time period to have that done for our lawyers to review it, for Metro Legal to determine if they are going to do a summary for item 837, and then to set a meeting to discuss that expeditiously thereafter. So that's my suggestion, and I'm thinking a week, and maybe we can. I believe our attorney suggested a week to get those materials to us, and then a week to consider them, and for our attorneys to weigh in.
I believe that would, by the numbers and the dates, wouldn't that make it so the Metro Council petition could not appear alongside the ballot? I think that would take it out of consideration just by our scheduling.
Potentially, it could if the Metro resolution, the language in it is enforceable, and it does render itself a nullity. I
don't think I understand.
Well, the Metro resolution does say that it's a nullity if it doesn't go on the ballot at the same time as the Good for Government petition. That's what it says, and that, in a sense, contradicts our authority to put things on the ballot. So if that's enforceable, then yes.
So
absolutely, you're absolutely right.
So just to be clear, I think I just want to make sure I understand what's going on. I think we just bent over backwards to make sure that we were working on 60 days for whether Metro could or could not be a home rule with a potential legal argument there. So if we're going to bend over backwards to make sure that anything could appear on a ballot that potentially has a legal argument to do so, I think we should extend that same courtesy to the Metro Council resolution and not take it out of contention by putting off the ability for us to vote on it and put it on the same date, because that is indeed action by inaction, which I do not think is the will of the Metro Council, or is it the purpose of what we're supposed to be doing here. I'm afraid that this might have devolved into a bit of everybody's trying to figure out which date does this and which date does that, and where does it put it, and I don't think that's what we're supposed to be doing. I would just like to make sure that if we have the ability to get some legal advice before we make a determination on the council amendment, and we can have it where we still have like a cutoff date so we can vote that it could be still on that same date if we choose that it goes on the ballot, that we make every effort to do that.
I'm informed that that may only give us 3 days. So we would have to take this up on Thursday.
I can be available on Thursday.
Question, and I'm strictly asking, if there's these many issues that has been pointed out by one of the council members here, would it be better if the council actually just wrote a better resolution and then got rid of this so it would be taken care of?
Unfortunately, I don't think we.
I know we don't.
I don't think we have that kind of authority.
I don't think we do either, but it just seems to be an issue.
Okay. So I think what, if that math is right, and please, everybody kind of look at that. If the math is right, then we would convene here on Thursday. Our lawyers may well tell us they have not had a chance to review it sufficiently. They may well say that. But I understand your concern, and I think what you're saying is you'd like to give it a shot. I take it.
Sure, we're paying our lawyers a lot of money, and I know they're both incredibly capable, and I'm sure that they can put together an opinion on a subject matter that they've already been researching for the past couple weeks pretty quickly. I know I've litigated entire cases over the course of 48 hours, so I'm sure that they're capable with their capable teams could get us an opinion on the legality of what's in front of us by Thursday. If not, I'm afraid any inaction at that point is a vote in and of itself, and I think we at least owe it to the public to vote. If there's a position that it doesn't matter what legal conclusion that the lawyers come up with, that we're not going to put that on the ballot for whatever reason, then, I think we should just make that decision today and let people do their thing as opposed to running up an expensive legal bill. Because I don't really have an interest in doing that. So if there's already kind of a predetermined conclusion here, I think we should just probably move on. If there's not, then, I'm happy to get that information from our very well-informed lawyers by Thursday, and they're so capable, I'm sure they can do that for us.
Chairman, I have a question for AOC.
I wasn't quite finished, but.
AOC, I don't know why I said AOC.
Finished.
AOE, Election Commission. Question, Mr. Roberts. If we push this to Thursday and vote on it, does that put us right at the 75-day threshold, or does that put us exactly, date-wise?
That puts us right on that's the last day you have is Thursday. Now, we're doing this on the fly, looking at these calendar dates, but I think Thursday is the last day you have to act to hit the July 27th date.
I'll make a motion to call our next meeting for Thursday, this Thursday, May the 13th at, I believe, 6 p.m. typically works for you. Is that correct, Commissioner Davis?
Say that again, I was counting dates.
I think normally the 6 p.m. meetings, we do those for your convenience. I think 6 p.m. normally works for you.
No, I've made my schedule around that. I've made a 3 o'clock meeting and others, so.
I can do 3 o'clock on Thursday if that's
Like
your
I said, I
preference.
try to work around other people's schedules as well. 6 p.m. seems to work for everyone, but I've been at 3
Is there
o'clock
anyone
meetings,
not
so.
available at 6 or 3? Do you have a preference, Commissioner Evans?
I can do 3.
Okay, I'll do 3 o'clock. So I'll make a motion to call our next meeting for May the 13th at 3 o'clock. That's the Thursday.
3 o'clock
I'm sorry?
3 o'clock's a problem for me. I have to undo some things.
I'm sorry, I can't hear you.
I'd have to undo some things, so I can't say definitively that 6 I could do, but 3 is going to be harder for me.
Okay.
6 works for our council. I think that's a good idea.
Is 6 satisfactory with everyone else?
6 works fine for me, sure.
Okay.
6 o'clock on Thursday, the 13th.
Okay. All right. I don't know if we need a motion, but if you want to make a motion.
I did make the motion, so
You
I'd
made the
appreciate a
motion.
second.
I'll second the motion.
Thank you.
All in favor, say aye.
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 Any opposition? No opposition. The motion carries.
At this time, then, I would make a motion to, I think we technically have to move, do we have to move item 4? I think in the
You
past,
wanna
we've made a
defer?
motion to move it.
We have deferred. If you want to make the motion to defer, the chair will entertain that motion.
I will make a motion to defer item 4, discussion and possible vote on the council resolution 2021-837 to our meeting that we have now scheduled for Thursday.
All right. Is there a second?
Second.
Okay. Okay. We have a motion and a second. All in favor, say aye.
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 Any opposition? With no opposition, the motion carries. That brings us to item 6, the AOE report, and I believe Mr. Starling has raised an issue concerning the withdrawal of signatures issue.
Commissioners, we have been collecting emails and written notification from voters that have expressed an interest in removing their name from the list. We began receiving those, I believe it was on April the 8th at our meeting. The state law defines in 25151G how you can withdraw your name. And it says you can do that within 8 days of the petition being filed. None of these that we received were within that time frame. Now, Davidson County is not part of this state law. It relies on the charter to define the rules as far as petitions, referendums go. The charter is completely silent on the ability to withdraw your name. So at this point, we've only been collecting the names. We have not considered any of those names as being withdrawn. And I think each of you know we're getting emails that are coming to multiple people. So we're trying to narrow those down, take out the duplicates, and calculate a total. But at this point in time, we have not spent time doing that.
I have some questions. Commissioner Starling, can I ask my questions? Okay. Are there any of these signatures, well, let me ask you this, are there any of the printed names on the bottom of these emails that make you think they're not real people that are sending them to you?
You know, one of the things that we had thought about, to put your name on the petition, you actually have to sign your signature. We, just common sense would tell you that if there was a provision to take your name off, you would have to do something similar. But we have a number that have only come in the form of an email, and we have no signature from that voter. And what complicates it, we may have a name that includes numbers that we don't have that voter, you know, it's not John 423.
Right. So you're.
It may be John Phillips, but it's not John 423 Phillips. So there's some complicating factors when we start looking at the withdraw your name request as to how we would deal with those.
Have any of those attempts to withdraw come in within the 8-day window that state law permits if that state law applied to Nashville?
We did not receive any within that 8-day window.
So basically, when people are, and then I got some this afternoon as well. I assume everybody did as well. So could that be challenged? Would that be another challenge that could come on about this from a legal standpoint?
Well, I mean, I have an opinion on that, but we've hired lawyers to address those issues.
Yeah. I don't know.
Have you all been following that? Let me just.
we were prepared for the for the other issues. We don't have a well-researched answer to that question. We would have to look to see what happens elsewhere. I have an instinct, but it's only an instinct, and I don't really want to say what I think is what. But I'm skeptical about withdrawals that are either not signed or after certification. I think certification is pretty much, there has to be a deadline. And I think certification is the deadline, but I can't, that's just an instinct. We can do the research on that. I'm not sure there will be an easy answer to that. We'd have to maybe look at other states. When I did look at this earlier on, before certification, it seemed that other states that had more referendums, more robust law, had developed an answer to that. And I think that it was all like once they had been submitted, but you know, I'm not really prepared to answer that, and I don't want to be pushed to give a definitive answer till we've had a chance to review it.
Is it a possibility to address this again on Thursday?
Yeah, we'll do what we can. It's a very tight time
Okay.
rope. I mean, we've been at this for a while, and we prepared a very comprehensive memorandum, and I'm not sure what we can do, but we'll do whatever we can by Thursday. I don't know that we can have a written report. We may have to do something orally and present the best we can, but it may not be definitive by then.
Okay, all right.
And that's fine, Professor. I just wanted to make sure that as the people are watching this afternoon know that the withdrawal petition was discussed and brought to a conclusion, that's all.
Okay. Well, we'll put that on our to-do list for Thursday. But you know, I don't always get all the to-do things done in the time that people would want. So we'll do what we can. And I've just been asking Austin. He's going to be he's got the resources of a firm behind him that he can put to work. And so we'll all be together, but we'll do what we can. I just don't want to give an answer, seat of the pants answer to that until I just know there has to be a deadline, but I'm not prepared to say what that deadline is. And I'm not sure Tennessee law specifies what it is. So we'll come back with some response, Commissioner Starling, to the best we can.
Commissioner Starling, are we set to give the floor back to AOE Roberts to continue his report?
Yes.
Okay.
Based on action taken today, we will begin preparing for a July 27th election. And if that should include the Resolution 837, we will package that on the ballot also.
All right. Is that your report? Any questions from the commissioners? Yes, Professor Blumstein.
Mr. Chairman, I just want to, Mr. McMullen raised a fair question. I just want to be sure that the concept of exigent circumstances in his retention letter and my retention letter covers this new task that you're asking us to do, so that we know that we're within the scope of our employment authority here.
Does that mean it's about to be very expensive?
No, it just means that we're going to get paid the way the exigent circumstances language suggests, at normal hourly rate.
I have to say that's kind of what I was alluding to before, Chairman, if I can speak. I don't mean to just
Yes, go ahead.
floor, but I mean,
That's fine.
But that is what I was alluding to earlier. I don't want to go turn the spigot on to something that's going to be very, very expensive. I mean, very costly, and invoking another provision of the clause in the contract is going to make this a very expensive endeavor. And if we could take a vote now, and everybody already generally knows how they're going to vote, that's going to save the taxpayers a whole lot of money. I mean, I can tell you right now, my legal opinion as a lawyer and as a commissioner looking at it, I don't see a flaw in what it is that's been presented to us by Metro Council. I've had those questions answered. So, I mean, if we need to take a vote today to save the taxpayers what's about to be an extraordinarily expensive legal bill, which I suspect it will be, I'm happy to just call the vote.
Sure. Mr. McMullen.
Mr. Chairman, if I could, my question didn't have to do with fees, it just had to do with the scope of the representation, because the scope of the representation and our engagement is defined as the for good government petitions. And since this Metro resolution is different, I just wanted to make sure it was in the scope of our engagement to offer analysis on the Metro resolution. The same discounted rates would apply regardless. I just want to make sure that it is within the scope of our representation as requested by the Election Commission, because in my letter, the scope is limited to the for good government petition.
Well, the question does relate to the for good government petition, I believe.
Okay.
Because it's just asking whether or not people can withdraw their signatures. So I do think you're within the scope.
Okay, thank you.
Okay. Does that handle everyone's concerns? Okay. All right. All right. We are to the public comment section. Have we had people sign up? If so, we welcome you to comment. Limit your comments, please, to 1 minute. And Mr. Garrett, you're first up. Thank you.
Mr. Commissioners and lady, I want to thank you for doing your job. As a citizen of this county, I think you've got a very thankless job, but I want to thank you.
Okay. Thank you. Mr. Roberts.
Thank you for the opportunity to speak with you very briefly. I want to thank you for all your hard work on this, and the people of Nashville appreciate what you're doing. This folder represents about another 1,000 signatures that we got in after the deadline or the date that we turned them in. You're giving the people of Davidson County 430,000 of them an opportunity to vote on this, and I appreciate that. They appreciate that. Mr. Mendes constantly referred to me as though this was my petition. He kept saying Mr. Roberts' petition. I think he mentioned my name 23 times, 24 times. Oh, excuse me. This is not my petition. This is the people's petition. I was the very last signature. In fact, the morning that we turned them in, I finally signed it. My signature was 14,009, and my wife's is 14,010. Mr. Mendes walked up here and he lied to you in his opening words when he said this was sponsored by dark money. And I challenge him to come forward and tell this committee or this commission where that dark money came from, because I'm still looking for it. Every penny behind this came from Davidson County citizens and voters, and I appreciate their effort. And I hope Mr. Mendes will come explain to the commission why he lied to them about this very important issue.
Okay. Thank you. All right, Mr. Holland.
Hold on, don't start the clock on me. I want something to pass out to you, Mr. Chairman. I know you'd like to get in there on me early. That's a copy of 1901 of the charter. I'm sure y'all read it, are expert on it.
I've got one.
I won't be one of you, good buddy. Thank you, Mr. Chairman. Here on behalf of the National Business Coalition, I appreciate Kabuki Theater as much as anyone. Y'all done a great job. Section 1901 of the Charter, I've highlighted. Such resolution or petition shall prescribe a date not less than 80 days. I'll let y'all read the rest. What does a date mean? Well, the Supreme Court of the United States on April 29 in Nee Chavez v. Garland said the court was faced with determining what a notice meant in an individual removal immigration case. A notice means a single notice, one. Writing for the 6-3 majority, my new favorite Supreme Court Justice, Neil Gorsuch, wrote, interpreting the phrase, a notice to appear to require a single notice rather than 2 or 20 does just that. At one level, today's dispute may seem semantic, focused on a single word, a small one at that. But words are how the law constrains power, end quote. Applying this case to what you've already done, a date is equivalent to a notice, and it constrains your power to place these matters on the ballot. Not today, but ultimately in court, you will be so constrained. And I am chomping at the bit to get there. Thank you, Mr. Chairman.
So we have already set the time and date of our next meeting. The next thing on the agenda is for us to go into executive session, and for the public, that's not to discuss anything that we've discussed here today, but it's to discuss a lawsuit that concerns the Good for Government petition from last year. So that is what we'll do, and then we'll come back on the record to adjourn, and that's for us now to discuss with our lawyer for that case from last year. Is there anything further from the commissioners? Okay. All right. Okay. Thank you all. We're going to stay here and going to discuss with our lawyers. Thank you. And for the commissioners, this might be a time, maybe we can take a break. You want to take a break?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.